Let's talk about one of the most powerful, yet misunderstood, tools in financial planning, the family trust. You might associate trusts with the ultra-wealthy, with dynastic families and billion-dollar fortunes. But that's a dangerous misconception. The truth is a well-structured trust is one of the most effective ways for everyday families to protect their hard-earned assets, ensure their wishes are carried out exactly as intended, and spare their loved ones from a costly public and lengthy legal nightmare known as probate. If you own a home, have retirement accounts, or simply want to make sure your children or grandchildren are provided for in a specific way, understanding trusts is not a luxury, it's a responsibility. In this guide, I'm going to demystify the entire process. We'll move beyond the legal jargon and break down, in plain English, what a trust actually is, the critical types you need to know about, and the precise, step-by-step process of setting one up correctly. I'll also show you where DIY kits fail and the non-negotiable role of a professional. This is about taking control of your legacy today. First, we need a crystal-clear metaphor. Think of a trust as a specially labeled box. You, the grantor or settler, create this box and write a set of instructions on it. This is the trust agreement. You then place assets into the box. This is called funding the trust. Those assets are now owned by the trust itself, not by you personally. You then appoint a trustee, which is like the manager of the box. The trustee's sole job is to follow the instructions you wrote on the box for the benefit of the people you named, the beneficiaries. This simple structure grantor, trustee, beneficiary is the engine of all trust planning. The magic lies in the instructions and the type of box you choose. The two main boxes, or types of trusts, you must understand are the revocable living trust and the irrevocable trust. A revocable living trust is the Swiss Army knife for most people. You create it, you can be the initial trustee managing the assets yourself, and you can change the terms, add, or remove assets. Or even dissolve the entire trust at any time while you're alive and competent. Its primary superpowers are avoiding probate and providing for seamless management if you become incapacitated. Because it's revocable, it offers no asset protection from your own creditors during your lifetime. An irrevocable trust, once created, is much harder to change. You typically give up control, but in exchange, it offers powerful benefits. It can protect assets from lawsuits and creditors, and can remove assets from your taxable estate, potentially saving your heirs a fortune in estate taxes. Choosing between these is the first and most crucial decision. So how do you actually build this box? Step one is not drafting documents, it's planning and inventory. You need to have a family meeting with yourself. What are your goals? Is it simply to avoid probate on your house and brokerage account? Is it to provide for a child with special needs without jeopardizing their government benefits? Is it to control how and when your children inherit, say, releasing funds at ages 25, 30, and 35 rather than in one lump sum at 18? Get crystal clear on your why. Simultaneously, create a master list of all your significant assets, real estate, bank accounts, investment accounts, business interests, life insurance policies. This inventory is what will eventually go into the box. Step 2 is where the rubber meets the road, consulting with an experienced estate planning attorney. This is the pro tip I cannot stress enough. While DIY online forms are tempting, they are a catastrophic risk for something as important as your life's work. An attorney doesn't just fill in blanks, they diagnose your situation. They understand your state's specific laws regarding trusts, property titling, and creditor rights. They will ask questions you haven't considered. What happens if your primary beneficiary predeceases you? What if your chosen trustee gets divorced or goes bankrupt? How does this trust interact with your retirement accounts, which pass via beneficiary designation, not through the trust? An attorney drafts custom, bulletproof language that addresses these complexities. The cost is an investment that will save your family multiples in legal fees, court costs, and taxes down the line. Step 3 is the actual creation of the trust document, the trust agreement. Your attorney will draft this, but you need to understand its key parts. First, the declaration. This names the trust, the grantor you, and the initial trustee often you. Second, the article on trustees. This outlines the powers and duties of the trustee. It names your successor trustees, the person or institution who will step in if you, as initial trustee, become incapacitated or pass away. Choosing a successor trustee is a profound decision. It should be someone financially savvy, utterly trustworthy, and willing to take on the responsibility. Often, people choose a trusted adult child or a professional fiduciary. Third, and most important, the distribution instructions. This is the heart of your instructions. How do the beneficiaries receive the assets outright? In stages? For health and education only? This is where you build in protections, like ensuring an inheritance isn't lost to a beneficiary's divorce or poor financial decisions. A trust can dictate that distributions are protected from the beneficiary, as creditors, a feature you cannot get with a simple will. Step 4 is the step where most well-drafted trusts completely fail: funding the trust. A trust is an empty box until you put assets into it. This is the most common and costly mistake. Funding means changing the legal title of your assets from your personal name to the name of the trust. For real estate, you execute and record a new deed transferring a property to your name revocable living trust. For bank and brokerage accounts, you contact the institution, provide them with a copy of the trust certification, not the full document, and they will rate out of the account. For vehicles, you may transfer title depending on state law. This process can be administrative, but it is absolutely mandatory. An unfunded trust is a worthless stack of paper. A pro tip is to also use a pour-over will in conjunction with your living trust. This is a safety net will that says, any asset I own in my personal name when I die should be poured over into my trust. It still has to go through probate, but it ensures the asset ends up being distributed under the trust's rules. Step 5 is maintenance and communication. A trust is not a set-it-and-forget-it document. Life changes. You get married, have more children, get divorced, acquire new assets, or your chosen successor trustee moves away. You need to review your trust every 3 to 5 years or after any major life event. You may need to amend it. Furthermore, have a candid conversation with your successor trustee and your key beneficiaries. They don't need to know every financial detail, but they should know the trust exists, where to find it, who the attorney is, and your general philosophy. This transparency prevents shock, confusion, and family conflict during an already emotionally difficult time. It turns your trust from a secret legal document into a clear expression of your love and care. In conclusion, setting up a trust for your family is a 5-step process of intentional planning, professional guidance, precise drafting, diligent funding, and ongoing review. It is the ultimate act of taking responsibility. It moves your family's future out of the unpredictable, public probate court and into the private, controlled framework you design. It provides peace of mind that your assets will pass smoothly, your children will be provided for according to your values, and your legacy will be protected. Disclaimer: I am not an attorney or a licensed financial advisor. This video is for educational and informational purposes only. Estate planning, including the creation of trusts, involves complex legal and tax issues that vary by state and individual circumstance. Nothing in this video constitutes legal advice. It is imperative that you consult with a qualified estate planning attorney in your state before creating any trust or other estate planning document. If this guide helped clarify the world of trusts for you, please support the channel by liking this video and subscribing. It helps us create more in-depth content like this. In the comments, let me know what your biggest question is about trusts or estate planning. Thanks for watching. And here's to building a legacy that lasts.